This is more of a public service announcement than getting into the nitty-gritty details of certain things, but I will be talking about some of the bigger pictures of where we want to proceed versus where other people are proceeding off of here. But it's exceedingly important for anyone who's using OER in academia. Let me phrase that. It's important for anyone in academia who uses any materials whatsoever, which is basically everybody. So first, I'm going to do like what I should do if I'm trying to really push things. I want to scaremonger. I'm going to give you a few things from the article. One is back in 2017, UC Berkeley had to remove 20,000 online videos from public access because the Department of Justice basically argued that those videos did not have proper closed captioning um, and were in violation of accessibility requirements. And Berkeley's solution, instead of solving it, was to take down the 20,000 videos. They're now working on a way in order to revamp it up. I think they've already brought up some of it, but I don't know the entire situation right now. 2019, and this continued on for several years, the LA Community College District was sued by several students for using inaccessible technologies. They were actually using Pearson's My Math Lab, which had some issues, and it ultimately resulted in about $250,000 in damages. Uh, The Berkeley situation also had threats of financial implications off of here. These things were empowered largely because of a 1990 law that Bush Sr. signed into law called the Americans with Disabilities Act, or the ADA, which most, if not all of us, have heard in one form or another. And the argument behind here is that it prohibits discrimination based on disability, broadly defined across the board. It's a unique law in the sense that it's designed such that enforcement of the law is based upon people who are infringed. So it's somewhat similar to a civil case, even though it's a criminal case backing it. So if a individual feels that they are infringed upon, they can then file a lawsuit and pursue their case within the ADA. And there's lots of interesting arguments or anecdotes about lawyers that are using this as a mechanism, as a cudgel in order to be able to extort money from various people like that. And that's in no way to suggest that all lawsuits are frivolous. That applies to academia as it does outside of academia. The ADA has 5 titles or classifications off of there. Classification 2 is the one that deals with public institutions, state and local governments, and that includes public education situations. So basically, all of us fall in line that because we are either in public institutions or we are certified by public institutions in order to be able to do the business that we do. So, what's the deal that's going on here? Well, last year, the Department of Justice, then under Biden, uh, implemented new regulations in order to essentially give stronger teeth to the ADA for materials that's used in the classroom. Uh, Specifically, it mandates that state and local governments make their websites and mobile applications accessible to people with disabilities, period. Now, the state of California had that law for a long time. However, it was not as widespread and followed as we would like it to be. This new regulation essentially gives stronger teeth in order to enforce that, uh, which means that everything that we do, and this is going to be one of the slides, just one of the slides for everything that we use in our classroom needs to be compliant with ADA. And that's when you're dealing with online technology, is the Web Content Accessibility Guidelines of the WCAG, and specifically 2.1 level AA. Now, this is again a public service announcement. I'm not going to jump into the details of what that means. AA, single A, 2.1, 2.0, whatever. But I will talk about some of the aspects associated with that just within a bigger picture a little bit later on. So again, their goal is to ensure equitable access to public service programs, activities, regardless of disability. There was some debate about whether the current foundation, the current federal government is going to continue pursuing this thing because it's not what people would think would be aligned with their sensibilities, but it does provide an opportunity for the federal government to use this as a cudgel in order to address academic institutions that are not following these things. And as I will make the argument, most, if not all of us, at some point or another, are not following or not fully compliant with these things. Um, so the date that I want to pit here is essentially, and there's some details behind it, but the upshot is for most, if not all, campuses that are have any significant size, it's going to be April 24th of next year that we need to be compliant. So if you haven't heard about this change of the Department of Justice, you will at some point within your campus as they start to address these things because it has significant consequences if we are not compliant with it. Uh, so what's the scope off of that? Well, it has lots of legalese and discussions behind it, but the upshot is essentially that all digital content that's hosted by a public campus or university must have their accessibility standards compliant, this WCAG. This includes all materials in public websites as well as those behind authentication walls. So you can't just basically argue that you need to have access to it in order to be able to deal with that. That includes your learning management system. Every part of your learning management system needs to be accessible, and every content that you store in your learning management system needs to be accessible. There's a certain caveat that I'll talk about a little bit later on here. So in other words, password protection restriction action does not give you a waiver from compliance. Now, if this doesn't scare you, it should. And if your administrators aren't scared about it, they don't know about this. But certainly, many attorneys out there are well aware of this, and there are many companies that are stepping up in order to provide their services in order to make universities compliant with these things. And I'm sure this is going to be a massive cash cow for many of those companies. We're not one of them. So, what this means is that everything that we have has to be compliant. And that includes the OER stuff that we are creating that requires the non-OER stuff that we are distributing, hopefully creating, and all our existing documents. Some of those things are easy in order to convert. Some of them are not easy, like PDFs, in order to be able to make accessible. So it's going to be a very time-consuming process in order to be able to do. Um, And part of that is because we need to be able to handle a wide variety of different aspects, structure correction, alternative text, tagging, and a few other things that's connected to that. And that's just in the documents. Technology will have similar issues off of that. So institutions are going to start prioritizing this traffic in order to prioritize high traffic content relatively quickly. So uh, this also applies to third-party content that's used in the classroom. As a third-party vendor, which is what we technically are, it means that everything we do needs to be accessible if it's going to be used in your classroom. If it's not used in the classroom, we are not under an obligation as a third-party private company in order to be able to address that, at least under Title II. Title III deals with private institutions, and that's a different issue that we might be seeing a little bit later on. So that means every contract license integration needs to have some accessibility guidelines off of here. I'm still trying to scare you, and actually, I don't think I'm going to stop scaring you for the remainder of this talk. So, following the ADA, the way that we used to be able to, the way that we did this before is that it was very passive. We waited for someone to complain and then went through a process in order to address it, maybe deal with the legal implications in order to be able to do it. We now collectively in academia have to be proactive and move forward with our content to make sure that everything is accessible as it should be. And again, every document, every web page, every tool has to be fully accessible from day one. Now, the Department of Justice doesn't change the retro, not the retro, but the way that the way that the ADA is still implemented in terms of a complaint in order to be able to address it, but provides stronger penalties in order to be able to do so, which might actually open up the case for more people in order to be able to do these things. Okay, so 1 second here. I have two daughters yelling. Hopefully you guys can't hear that. Okay, good. So I'm going to ignore that. Okay, um, so what does that mean? It means that all the OER that we are creating, whether it's from our platform or before our platform, has to be built, distributed, and adopted to be compliant with ADA. Otherwise, campuses will have financial penalties. That includes all text that we create, all videos we create, all audio we create, all interactives, all distribution exports, all files, and all technologies. Now, that is a lot. But I want to emphasize this thing that's in the bold here. It says, or have alternatives. So if you have something that is not accessible, but you have an alternative that is accessible, that you have access to and used in an accessible manner, that right there will still be compliant with ADA in order to be able to move things forward. And that's something that we use and adapt. If you remember yesterday, I was talking about briefly that you have a main question type, but you also can have an ancillary question type that a student can have if they require that level. It's not technically accommodations. It's just an alternative that can be accessible if the first main question is not accessible. And that can be extended into a wide range of these things here. So this is not meant for you to be able to read relatively quickly here, but there are a wide range of things that need to be addressed in ensuring WCAG compatibility, including contrast, alternative texts, improper structure, captions, and the underlying technology behind it. We'll talk about a little bit of this when we discuss some of the technologies that you have access to in the LibreVerse infrastructure, but this is some of the things that are oftentimes not addressed very well. So I would like to emphasize that a lot of the OER that's been created in the past has been created without accessibility in mind. In fact, significant amount of OER is inaccessible, and even much of the OER that's creating right now is not created in a way that is compliant with WCAG. So there's a lot of activity that needs to be done in order to be able to bring up the corpus of OER to WCAG 2.1 compatibility, and hence to be protected against financial penalties associated with this. Imagine that you are creating an OER platform or OER book that may or may not be accessible, and ask the question if you think that administrators that will be concerned about the financial penalties of using non-accessible content will be very excited about you bringing something in without having a full accessibility component. So there's some arguments that this might have some consequences in terms of adoption of OER in the future. So the and even many of the OER that is created without a full formal accessibility review or BPAT that's out there. In fact, almost no OER, maybe with the exception of OER, goes through OpenStax, that is, goes through a full VPAT review process because it's actually time consuming and financially consuming. So what do we have to do about that? So we have one of two situations in order to do so. One is either to hide the problem or one is either to fix the problem. Yeah. Hiding the problem basically constitutes saying that the content that you have, the OER content, is archived, which means that it's not used in the classroom and you put it aside separate from the stuff that's used in the classroom. And that right there is very similar to how Berkeley dealt with the videos that they had in the 2017 case that I talked about at the start of this presentation. Is basically move it away and let's not worry about it afterwards. Fixing the problem takes a lot of effort in order to go through and be able to address that. That is what we favor to do. So while our platform is accessible, we don't confirm that every person who makes content on our site is doing it in an accessible manner. We do have bots in order to be able to handle many of the basic principles, but we don't actually have a mega bot in order to force everything to be compliant with WCAG. That's going to change. So we're working on building a bot that will go through a book and convert it all to WCAG. It might change it change it into something that the original authors did not envision, but it will be compliant with WCAG once we actually have that infrastructure in place. So that's the stance that we're planning on doing in order to address this, in order to make sure that the corpus of content that we're sitting on, which is 1.5 million pages of OER, can still continue to move the community forward, rather than throwing everything into the archives, putting our fingers in our ears and go la 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 la, which unfortunately is what some of other platforms are doing on here, because we do this because we actually don't claim an ownership of the content that we host, but we do have it within the spirit of being able to curate and bring things forward off of there, in contrast to other platforms that just basically host and their hands are up in terms of what's actually put down. And I'm happy in order to talk about how we actually progress with this in the next half a year as that date comes in. So the future is open. I also think the future is going to be accessible, and we're going to be more aggressive in order to make sure that people are creating accessible content on our platform. That also means not just the content, but retroactively reviewing each of the technologies and trying to push and address that's the case. And some technologies are harder to handle accessibility than others. For example, Jupyter has issues with accessibility that we want to be able to work with people in order to be able to update. Okay, with that, I am done. I'm happy to answer any questions or concerns that people may have regarding this or the ways that we're trying to address it. And I'm also happy if you want to go into the nitty-gritty details of some of the issues that we focus on. But again, this was meant to be a topical overview of stuff, not necessarily a specific aspect.